Hello, welcome back to the chapter 6 for the business law. This is in terms of copyright is owned by McGraw-Hill. This slide is owned and prepared by John Piccolo of Niagara College. Okay, we will have for this particular chapter 6, we have a number of key objectives, which is number about 6 of them. This is in terms of continuous of contract problem with the formations. Okay, let's look at the learning objective first. Number 1 to 6. Know the problems can arise in forming a contract. Correction number 1. Number 2. Examine the effect of a problem information will have on a contract. Number 3. Recognize the two ways legality can render a contract void. Number 4. Knows what effect the capacity of another party has on contract and understand why mistake may have an effect on contract formations. And 6. The difference in three types of misrepresentation. Three requirements. What cause problem in a contract formation? These three requirements to have a valid contract. Each party must have the necessary capacity to enter into the contract. The contract must not be contrary to law. The contract must be entered into voluntarily by each party. What cause problem in contract formations? Okay, void contract. A contract regarded by the court as never having existed with either party able to enforce anything under it. That is called a void contract. Voidable contract is a contract whose defect allows one of the parties to end contract as if it has never existed. In terms of the formation, introduction to the formation problem in contracts such as legality, capacity, and voluntariness, there are three elements that means that if a contract is enforceable. What are those? Legality, capacity, voluntariness. There's three elements. Okay, remember, guys, in to be enforceable. Okay, we're gonna look at this in terms of the detail. Legality. What is legality? The purpose of the contract must be legal, and even if legal, must be one of the court of law believes should be enforced. Example: your friend refused to pay you after winning a bet on a hockey game. Cannot be enforced due to the public policy. Okay, if it is bad. Okay, because of public policy. Capacity. Capacity is used by the law to protect those people we consider vulnerable. What are the parties understanding what they were getting into? If not, should they be allowed out of contract with few or no consequences? Can be denied based on age, mental infirmity, but set out on the conditions. Okay, that is capacity. Voluntariness. Recognize that a contract should be a voluntary undertaking by all parties. Review factors such as mistake, mispresentations, undue influence, and duress. The parties must enter into contract with their eyes open and not due to invalid action by the other party. Beyond the basic legality, the purpose of a contract must be a legal one. Example, contract to steal a car is for illegal purpose and will not be enforced. For example, okay, you are contract to steal a car, that's no good. It's not enforceable because it's illegal activities and theft crime. Okay, public policy also affect the legality of a contract. Deal with matters that the court feels society would not wish to promote. Example is baiting. That's a good example. Okay, beyond the basics of the legality, we continue here. A contract that has purpose that is illegal or against the public policy will be rendered as void and or unenforceable by a court. For example, no compensation will be available for either party. For example, here, contract for surrogate motherhood would not be enforced as commercial transaction except for compensation for expenses. Okay, surrogate mother. So in this part of the world, it's not considered enforceable. Being surrogate mom. And then beyond the capacity, in terms of capacity and voluntariness, again, capacity is that the parties must be capable of understanding what they are getting into. If a party is deemed to be vulnerable, then the person may have lacked the capacity to enter into the contract. Okay, let me just check what's going on there. There's some Let me just turn on the volume. So turn on the volume first. My apology. There's some kind of call coming up. Okay, let me just turn it off there. So let's continue again where we are now. We are at this particular capacity. People without capacity, which is minors or infants, as a general rule, is that a contract made by minors will not be enforceable against them, but will be enforced for them. A minor that has an option of not performing or ending contract with no liabilities. I keep hearing these sounds. Let me just clean this one up. What is not supposed to be there? All right, let's continue again. Let's continue. A minor's example without capacity 1. A general rule is that contract made by minors will not be enforced against them, but will be enforced for them. A minor has the option not performing or ending contract with no liability. Minors means people under the age of 17 or 18, okay? Because depends on the law. But most people is under 17 is considered minors. In okay, minors or infant, there are two exceptions to the rule. Exception for the beneficial contract or service or the provision of necessities such as job and practice, food, clothing, and lodging. The consequences when a minor repudiates a contract where the other party has already fulfilled all or part of their obligations. Okay? And then diminish contractual capacity. People without capacity. That the person at the time of contract was formed suffered from recognized conditions that affected by their ability to appreciate the nature of a contract to which they were agreeing. That the other party of a contract knew or should have known the conditions of the time of the contract was formed. That the person claiming incapacity or someone with authority to act on their behalf took immediate step, terminate the contract upon being aware of it regarding the capacity. So this is for the people without capacity, such as minor or people that is mentally disturbed or something like that. Okay. No, under the contractual capacity. People without capacity, other entities that with liability or no capacity, such as corporations, labor unions, enemy aliens, aboriginal people, bankrupt debtors. Okay. With limited or no capacity. Voluntariness. Concern with why party enter into a contract. If party entry into contract was without the necessary voluntariness, it can be used to end the contract. Must show that the other party either deliberately or accidentally active deny them with voluntariness. Okay, what are the things? Mistake number 1. Mistake number 1 is that mistake wrongful belief about the terms of a contract that cause the person to enter it. Okay, the person presume all parties to know the law. Mistake of law is no defense. Okay, but you don't mistake the law is no defense. This is no good. The court will not repair a mistake of judgment into entering a contract. That's mistake number 1. If you said you don't know, then it's no good. Okay, it's not a good defense. Mistake number 2. Two types of mistake recognized by the court. Mistake about the terms of the contract. Mistake about the assumption and subject matter of the contract. This is mistake number 2. Recognized by the court. Mistake can be made recording the document in writing such as typo. The usual remedy for this is that it's called rectification. So that's another mistake number 3. Can be made during the typo. Mistake number 4. Sometimes misunderstanding about the meaning of what will arise. Party may have different interpretation of an ambiguous or unclear terms. The court will give the term the meaning that is the most reasonable under circumstances. That's the key part. The court will give the term meaning that is the most reasonable under the circumstances. Excuse me. Mistake number 5. A special type of mistake is known for non-ex factum. A contract made under non-ex factum voidable if the signer could not read it, or the signer was not careless, and the subject matter is completely different from the signer belief. Okay? And then in terms of e-commerce, there's two particular concerns with mistake made in e-commerce transaction. A single keystroke error, hitting the wrong key or clicking the mouse or screen at the wrong place, sending command that has legal consequences. That is the most particular in e-commerce. Okay. relying supermarket agent to complete their side of the contract formations on the e-commerce. So be careful on the key commerce there. And then misrepresentation, undue influence, and duress. Duress is under stress. A party will have the option to void the contract if misrepresentation, undue influence, or duress has occurred during the contract formation. Duress under stress, under heavy pressure of influence. Okay. Misrepresentation number one. Two types of misrepresentation. The first one, fraudulent misrepresentation. A false statement deliberately made by one party about important terms in a contract that they know what was the reason why the other party agreed to the contract. Innocent victim has two options. They can void or end the contract, sue for the damages under the tort or deceit. Okay? Misrepresentation number two. Two types of misrepresentation, okay? Innocent misrepresentation means a false statement made by one party about the important term in a contract, which they, in good faith, believe to be true, and that was the reason why the other party has agreed to the contract. A party was misled without active intent to the other party. The innocent party can void the contract if they do not promptly after the learning does not so promptly after the learning of the misrepresentations, or and if no other innocent third party is negatively affected. Yeah? So let me repeat the sentence here. This is a good one. The innocent party can void the contract if it does so promptly after learning of the misrepresentation and if no other innocent third party is negatively affected. In terms of utmost good faith, this is the key part. Utmost good faith means a duty to disclosure arising out of special relationship of trust between the parties. For example, in the contract of insurance, the insured has a duty to disclose changes in circumstance might change the risk. For example, on insurance, I've claimed to have no convictions of DUI, okay, drunk driving. So, in order to avoid the charges of premium, so I have to disclose it. Utmost good faith means you have to disclose it in good faith. You disclose it. If you do not disclose it, you are violating this concept, utmost good faith. Okay. Contract with consumer, there's a duty for supplier to point out the terms that may be different from those that our consumer might reasonably expect. For renting a car, the person buys extensions and the person does not read exemption clause does the clerk point out the limitation. That's the key part. Okay. Extra insurance. Okay. Undue influencement. Influence a party into entering a contract through the abuse of a position of dominance. Determined by the circumstances of relationship, must be mental domination of one party over the other to the extent that the person is robbed of a free will. For example, in the case of teacher students, spouses accounting to the clients. Okay. Undue influence is presumed in a family relationship with inequality, relationship where one party possesses specialty or knowledge, relationship where one person is in dire straits. Duress. What is duress? Duress means coercing party into entering a contract through the threat, use the threat of use harm to their person or their reputation or their finances. This can avoid the contract. A person under duress must act promptly once the threat is removed and prove they had reasonable repression to the threat being realistically achievable. For example, someone put the gun into the head and ask them to sign. That is called extreme duress. Okay. Example: extreme duress. Three types of threats: causing harm to the person, causing harm to their reputation, or blackmailing, causing harm to their financing, such as threatening to fire someone if they don't agree to the contract. That's the key part. And then what are the key questions here in this particular objective? We're going to go step by step. And the quick question. Number one is, what is the void contract? And what is the voidable contract? 624. Can you get out of online contract or agree on error? Okay, that's the key part. Can you get it out? What are some of the issues concerning minors under contract? Minors, people that below 17 or 18 years old, depending on which province or state in the U.S. What does it mean if a contract is against public policy? Okay, 6.3. Can you get out of contract due to intoxication? For example, you're drunk and you sign a contract without realizing it. What is the difference between fraudulent and innocent misrepresentation? So fraudulent is intention. There's an intention to be fraudulent. Innocent is no intention at all. Okay, is there a difference between duress and undue influence? That's number 6. Let's look at the key term step by step. Key term 1, void contract, a contract regarded by court as never having existed. Voidable contract is a contract whose defect allow one of the parties to end the contract as if it had never existed. Legality is the purpose of a contract must be legal and even legal and must be one that a court of law believes should be enforced. And then public policy. What is public policy? The purpose of the contract must not conflict with the interests of society, and capacity means the parties must be capable of understanding what they are getting into. And mistake are the wrong belief about the terms of a contract that cause a person to enter into it. Fraudulent misrepresentation is a false statement made by one party about the important terms of a contract that they know was a person why the other party agreed to the contract. Innocent misrepresentation means a false statement made by one party about the important terms in contract which they in good faith believe to be true, and that was the reason why the other party agreed to the contract. And then utmost good faith is that a duty of disclosure arising out of the special relationship of trust between parties. Undue influencement in influencing a party into entering a contract to the abuse of a position or dominance. Duress. Duress means coercing a party into entering a contract to reduce the threat of harm to their person or their reputation as well as their finances. Those are the 4 key terms. Okay, there's 4 of them that you have to know. What are the key form? Key term 1 here, slide 1, slide 2, and slide 3, and then slide 4. Okay, these are the key terms that you need to know. So I will post this in YouTube as well as I'm going to prepare all the questions in the Edpuzzle so you can understand it. Okay, thank you, everyone. Bye-bye.